Let's continue getting reaction now on the decision by Judge Piet Koen, who is considering recusing himself from the arms deal trial. The matter has now been adjourned to the 30th of January 2023. Let's speak to legal analyst Mpumelelo Zikalala, who speaks to us via the virtual platform. Mr. Zikalala, thank you very much for your time. Are you surprised by the decision taken by Judge Piet Koen? I suppose it's not a firm decision yet, but he's asking lawyers to tell him whether he should recuse himself from this trial. What would have precipitated that in the first place?
I'm not surprised at all. In fact, on the last occasion, I was simply saying to them, I'm begging you to find something which you are going to submit that I'll have to adjudicate on. Of the firm belief that I may be conflicted in this particular matter. I've made a few utterances previously, either during these short stints or short presiding sessions in which we are checking out the housekeeping issues. I've made certain decisions and made certain comments, which when viewed broadly may maybe paint me in a manner in which I may be perceived to be biased. But most importantly, remember the recent judgment, which I think I was checking in October 2021. It's quite a lengthy one. If you look at it, there are certain pronouncements which have been made, linking directly to the private prosecution stances and the manner in which it ought to have been done. Certain pronouncements as to how the interpretation of the protection of the rights of the former president should be. But I think what we should do is to look at the Constitution in Section 35 and exactly what does it say about the rights to a fair trial. Very, very important factors that we must consider, which I think the judge is starting to look at them in a different light. The first one, the trial must start and begin within the shortest amount of time. He's certainly done his job in making sure that he's trying to close the loopholes as they are. Second one, to adduce and challenge evidence. Now, if you're going to stop a person from challenging evidence, including evidence which may be related to him or maybe can have a different view or sway in different direction is a problem. But the most important one, the right to appeal or review to a higher court. That's a very important right in which must be attached to be given to any person who is then regarded as an accused. So if you are going to diminish those rights, it must be based on things which are very important, certain circumstances which are crucial, and at the end of the day, that you could be able to prove. If you are going to pronounce on those issues, we are going to have a problem at the end of the day.
In short, Mpumelelo Zikalala, are you saying that Judge Piet Koen is worried about his integrity as a judge? I ask you that because in what he said this morning, he says the integrity of this trial must be beyond criticism. Is that an indication that somewhere, somehow, he thinks that he may have said things that could come back to bite him?
You are quite correct. In fact, it's two things. One, may have said things that may come back to bite him. Either those things were said during these pre-trial proceedings that have been taking place to check whether the stage of readiness of both parties is close to completion, or in that judgment which was taken or that he penned down in October last year, 2021. I think on those ones, there may be a certain pronouncement that he has made, and those deal directly with the right to a fair trial of the former president. In those ones, an inference can be drawn that you've already taken a decision. You've already assessed this particular situation, even though evidence has not been adduced or provided to you. You've made inferences in which evidence should not have been considered at all. So if you are going to make those type of inferences before the actual merits of the trial have been started, then are you going to be a presiding officer who's going to be able to deal with the matter moving forward? I do believe, though, that there may be a solution to the problem that they are finding now of separating the two proceedings and saying that pre-trial proceedings must then be handled by another judge. And when it gets to the merits, let a fresh judge who's going to sit in and listen on the matter and say, I'm fresh on the bench. And make it a full bench if you have to. I'm fresh on the bench. I'm going to listen to evidence as it comes in. All the preliminary issues that's been taking place were not decided by me. My mind has not been affected by anything, has not been tainted by anything. I'm simply here to hear the merits. State, you can start with your matter. Defense, you can provide evidence which disputes that, if it is that we'll ever get to that particular point in time.
I'm not sure how to phrase the next question to you, Mr. Zikalala. And whether or not I'm using the right words here, how much of this decision is also about self-preservation by the judge? Why am I asking? He is among the candidates who are vying for a position at the Supreme Court of Appeal, if I'm not mistaken. Is that also, or could in his mind be weighing whether or not he could prejudice himself for that position that he's hoping?
But on those positions, I think his name was excluded, if I'm not mistaken, from the list of candidates that could have been recommended by that was recommended by the JSC. Maybe we would be hoping that in the next tranche, when there's an opening, then come in and make those particular applications. His mind could have been alerted to the fact that, when you go to sit in these interviews, these are the type of questions in which you are being asked, and the way in which you adjudicate your matters is then questioned. And I don't want to find myself in that particular situation. But the one that I'd like to believe that is influencing this decision is simply saying, on the rule of law, on the principles of legality, on the principles that have been laid down by our constitution, I'm then, as a presiding officer, being given a specific duty to make sure that I'm able to protect the rights of all the litigants which are in front of me, the NPA or the state, and also the accused in this particular matter. But most importantly, when it comes to the accused, I have Section 35 of the Constitution that I need to uphold. Most importantly, the right to a fair trial, and also all the principles is laid down in the Criminal Procedure Act as to what procedure should be followed when we're handling this type of criminal cases. If there have been instances in which I have made mistakes, I do not want to change the whole case. I just simply want to make sure that I'm able to save whatever that can be saved of the case and let the person be exonerated or be found guilty purely on the basis of evidence which is going to be presented, and not on instances or things that have gone into, or the manner in which the case has been handled, which is, at the end of the day, is going to have a direct impact of whether the president is guilty or not. So at the end of the day, he's simply saying, I want to preserve the rule of law. I want to preserve the integrity of this particular court. I want to make sure that whatever decision is going to come out of this case attend division is going to be one which is solely fueled by the merits, accompanied by the applicable legal prescripts.
Final question. How do you convince a skeptic who says, it's been 15 years. We have seen one postponement after the other, appeal after another. Now, a judge is ready to recuse himself. Should this case be struck from the roll, once and for all?
Let's look at it from the side of saying we want to see that everything's been done in a fair manner. In this particular sense, we need to make sure that the rights of the constitution of the accused are preserved at all times. Those are the most important rights that a person could ever have. And the right to a fair trial simply means that every single matter that needs to be adjudicated must be adjudicated by the parties. And if there needs be, there are certain submissions that must be made to the court. Make those submissions. Let the court decide. If you are unhappy about those, you have a right to appeal up until to the court, and then you can come back and deal with your matter if you are not successful. So it is merely the exercising of one's rights when it comes to making sure that no matter how one would want to tell it, either they call it a Stalingrad strategy or whatever strategy they want to advance, at the end of the day is the protection of the rights as they are. However, there may be a solution to all these things in terms of saying, in any litigation matter, you're not going to get what you want all the time. There are going to be certain compromises that you are going to need to do to make sure that if you want progress in the matter to move on, that's exactly what you are going to do. So if the parties can sit down together and say, what are the cause of concerns that you may have in this particular matter? If there are those sort of concerns, okay, let's remove them, then you can be able to proceed. Where am I going with this story? The sitting down and saying that Advocate Piet Koen must be removed as the lead prosecutor, he stays as, for lack of a better word, a backbencher, but he still be able to provide the vital information and strategies which are required. And let another individual who is not tainted with all these things in which is alleged to do, to sit up or to stand up and say, I'm now the lead prosecutor in this matter, let's get on with it, would have removed all the appeals which have been now taken place and are going to go all the way up to the court, and all other causes of concern which are going to be there. So the former president is going to say, the personal vendetta against me, And the state is simply saying, we want to make sure that anyone that we want to prosecute this particular matter is able to do so. But a compromise between the two, I think, would assist both parties in terms of making sure that this matter is done and dusted and we are able to move on forward. My worry, the quality and the quantity of the evidence must be displayed or be submitted to the court from both parties. People at the end of the day are going to die. They're going to die with vital information. Important documents are going to be destroyed, which can't be used at a later stage when evidence needs to be adjusted. So if they really say both parties, we are in this to make sure that in the interest of justice, we are protecting our rights, then some type of a compromise must come from both parties.
Mpumelelo Zikalala, thank you very much for your time. And that's it. Thank you very much for that analysis.